Welcome to the third panel this morning. If you'd like to introduce yourselves, Mike, would you like to start?
Sure. My name is Michael Kiln. I'm the Chief Executive for the Nighttime Industries Association. We represent just under 10,000 businesses that operate between 6 p.m. and 6 a.m. in the morning, and that representation comes from things like the casino sector, events, festivals, clubs, bars, restaurants, etc.
Thank you. And I think we've had you as a witness before when we carried out our inquiry into spiking.
Yes, you did. That's right. Yes.
So it's nice to see you again.
Thank you very much.
Mark, would you like to introduce yourself?
Certainly. My name is Mark Gardner. I'm Chief Executive at Community Security Trust, which provides security for Jewish communities across the UK.
Thank you. And perhaps if I just start with your reflections on the bill and any just general comments you want to make at this stage. Mark, do you want to start? Because obviously we're very interested in your perspective, providing security already in synagogues and other places. So do you want to just give your view about the bill?
Sure. I think the bill overall is a good thing. It's motivated for all the, well, it's correctly motivated for the worst of reasons, if I may put it like that. I think society needs to better understand that we're all at risk of terrorism, and in today's statutory environment, it strikes me as correct that there's going to be an obligation to plan around risk and to attempt to mitigate against risk. So broadly, I'm in favour of it. Community security, for me, should be at the heart of this, though. And this is the ethos of Community Security Trust, the organisation that I represent, and the work that we've also tried to do with other faith communities and other people of protected characteristics through a sub-programme called SAFE, which stands for Security Advice for Everyone. And the basic principle for this is, if I attend a synagogue or a mosque or a Hindu temple or a church, week in, week out, if I'm a volunteer at that building, or if I work at that building because I'm the rabbi or the imam, then actually I know better than a commercial security guard, and I even know better than a police officer, who does and does not look out of place in and around those premises. I also better understand the premises themselves and the immediate environment. So I should be better placed to identify somebody who may be carrying out hostile reconnaissance. I should be better placed to know where you might evacuate, where you might hide, where you might evacuate, how you might shut the door, how you might barricade the door, who you might report to if you see suspicious activity outside the premises. And that's really what community security, leading to, depending upon community awareness and community intelligence, is all about. Providing a mechanism whereby people can just understand what I would consider to be the basics of being aware, but not being alarmed, being alert and supported, but not punished. Last year, for example, we had 235 reports from across the country of what people deemed to be suspicious activities in and around Jewish communities. Within the detail of those, 140 were cases of people taking photos or video footage of synagogues, Jewish schools, etc., when they didn't really seem to have any good cause to do so. And another 57 attempts to enter into Jewish premises, again when people didn't really seem to have good cause to do so. And obviously we forward that information to relevant local and specialist police forces, and that's the first layer of security, just being aware of what's going on around you, what might constitute planning, hostile reconnaissance in advance of, God forbid, a terrorist attack, knowing what to do about it. And if, God forbid, something did occur, as I say, how do we shut the front door? Where do we run to, either in or out? Who do we tell? These are the basics, and I think it's not unreasonable for places of worship to at least have a written plan as to where those things are, and for the people that use the premises most regularly, just to be aware of it and to know how they might respond if, God forbid, the worst happened.
And the way the bill's drafted at the moment, do you think that it's proportionate? Do you think it deals with the points that you've just made?
Unfortunately, any legislation is going to have to make arbitrary levels. I understand why it says 100 and 800, but there was questioning earlier. The threat does not depend upon the size of the premises. The threat depends partly on the nature of the premises, but also who's entering the premises. So, the tragic murder of Joe Cox MP. The attack occurred outside a library. The threat to the library every day of the week was not the same as the threat was the day that Joe Cox was going to hold a constituency meeting there. And the attacker carried out a lot of hostile reconnaissance prior to the attack, as did the attacker in Manchester. Take the attack on David Amos. The attack on David Amos, the murder of David Amos, occurred in a Methodist hall. It wasn't an attack against the Methodist hall, it was an attack against him. So the threat is fluid depending upon what the premises are being used for. It's very difficult to expect essentially members of the public, even if they do have some responsibility at a place of worship, to understand when the threat to their premises may alter to such an extent that a terrorist plan needs to be put in place. So I think it's probably better that every place should be made aware of the threat of terrorism, should be made aware of the need to plan for if, God forbid, anything should occur. And you're going to have to pick a number out of the air, and 100 and 800 to me does not seem too unreasonable.
Thank you. That's very, very helpful. Mike.
Thank you. As you can appreciate, our industry is very broad. The encompassment from large-scale festivals to 100-capacity pubs gives us a very broad range of consideration around the proportionality principle. We're also aware that we're quite heavily regulated through the Licensing Act 2003, Health and Safety at Work, the Private Security Act, etc. And we do have or foresee some impacts or concerns that I think is important to raise, and I completely agree with my colleague here with regard to the fact that the arbitrary nature of 100 and 800 capacity businesses, when every public space that is exposed could be a potential target. There are a few things, as you can appreciate, with our industry that I think are important to highlight, which will dictate the impacts on this bill, particularly the regulatory position. As I stated earlier, we're already heavily regulated. The Licensing Act 2003 framework sits amongst licensing objectives for premises and event licenses that looks at and includes public safety and the prevention of crime and disorder within those considerations. And it's very, very important that this duty aligns itself and integrates somewhat with existing legislation and regulation and guidance with the way that many of our businesses operate, the people that we represent. Where we foresee impacts outside of some of the pieces that my colleague has brought up is under a multitude of headings, really. We foresee some big issues with regard to the language that's used within the bill, particularly as we suffer quite heavily under the licensing regime, where there are ambiguity within some of the wording and language that is used, and that has a risk of discrepancy in terms of implementation, and also has a contested position between operator and regulator.
Can you give an example, just so we understand that? What would that mean?
It's well, from the perspective of and within this bill, when you look at a reasonably practicable, what does reasonable mean, or what does within the bill vicinity? As you can appreciate, if you talk about a vicinity, is that, 1 mile up the road? Is that, within a local area? We need to have some specifics which present a very clear understanding of where the responsibilities lie, just as two examples which within this bill will present some sort of challenges sort of moving forward, and does need some very clear understanding between the protection of public and private space, and where the responsibility sits between the state and the policing mechanism and the ownership of a space, or whether there is an integrated, proportionate partnership between two, which already exists in many respects. So bringing that forward, things like scope, where there are considerations for specific operational areas under specific business categories. For instance, if you have an event or a festival, they have a build pre the public access, and how that sits in terms of this protection, this duty. The perimeter in terms of a definition, open access events like marathons, Notting Hill Carnival, and where they sit, particularly things like non-ticketed New Year's Eve, and things like travel hubs, which have been mentioned. Primacy is another piece where you talk about complex management of events and situations where there is an integration between public space and private space, how that is managed moving forward, and also how the regulatory bodies work with each other, I think is really, really important. Responsibility, as we said, vicinity is a really key element here. There is a disparity between the way the police and local authorities within licensing decide where the vicinity or your responsibility lays in terms of outside of your premises, or whether it's half a mile up the road, or where your customers go. And we see that within grey space like Wembley Way, O2 Walk Up, and similarly the Manchester Arena example. And I'd reiterate this real clarity that needs to be presented in terms of private and public space management, and where the state responsibility sits and where that integration comes in.
Can I just stop you there? I'm just wanting to check. Marco, would you like to ask any questions? Because I know you have to leave it shortly. Sorry, just to make sure.
I really would rather listen
to
that's more interesting. I know there'll be future opportunities.
Yeah, okay, thank you. Sorry to interrupt. Do carry on.
No problem. Yeah. Thank you. So also the regulator, the consistent support from the regulator and how those regulatory bodies interact with each other are going to be vitally important because of the amount of regulatory controls that we sit within. Reasonability. I mean, we talk about premises and events, but what is a reasonable step, a reasonable measure? How is that measured by the regulator? Are they going to be an arbiter to that position? We already know that the intelligence levels within the state and policing are much greater than the private sector, and how will that sort of integrate in terms of that responsibility? They are some of the examples that we're talking about, and just to reiterate, from language, consistency, scope, perimeter, primacy, responsibility, regulator, control and consistency, depending on who regulates us will depend on the approach to this duty, and then we'll have a greater understanding. So there is a broad challenge around not having the required detail to really sort of dig down into how this is going to impact our sector as a whole.
And have you been able to have any dialogue with the Home Office in the drafting of the bill to raise your concerns about the other legislation that obviously governs what you do?
We have highlighted this alongside many other industry associations, and we are still sort of waiting to receive more information, but we are integrated with the likes of NACSO and the Home Office to a point, but we still haven't had great clarity coming forward. It's taken some time even to get where we are today.
Okay, thank you. Lawton?
Thank you, and apologies I missed the opening minutes, Mr. Golden, of your comments there. Can you both comment on, and this is something that's come out earlier, as to the differentiation between the commercial sector and commercial venues, who have to go through all sorts of regulatory hoops already, and the voluntary sector, what I call the village hall scenarios, where mostly run by volunteers for a whole range of fairly low-key but important events. And whether you think that there should be more exemptions for those sorts of village hall activities without undermining what is needed in the bill, as was shown by the shortcomings of the Manchester Arena tragedy, that would make sure it's more focused where there are greater risks. Would that be a problem, Mr. Gardner?
No, that's not a problem. I'm the chief executive of a charity that employs nearly 100 people and has 2,000 active volunteers who carry out security, counter-terrorism security duties at synagogues and Jewish events across the UK. We're a registered charity. I don't think there's any shortage of governance demands, legal demands, etc., etc. I presume that most of the premises to which you're referring are probably charities of one sort or another, and I think they probably already have quite an onerous burden in terms of the performance of staff, the performance of trustees, and the oversight, the performance of volunteers, and the oversight duties of trustees. I don't honestly feel that this need be a huge burden in addition to the burden that they already carry legislatively. I think it's a bit like health and safety. When you look at health and safety, it can appear to be overwhelming. You could take the attitude of, yeah, look, I know I'm supposed to do that, but really, who's going to bother? But actually, if you do carry it out, then you end up with a better, safer place of work for staff and volunteers alike. And I think that this ought to fit into that, but that, for me, depends upon the attitude of the regulator and the way that the legislation is enacted. I think it should be there to encourage and enable local venues, church halls, village halls, etc., to have a much closer relationship with the relevant local police, the relevant local council, all of the protect duty, all of the apparatus that is in place already for counter-terrorism. I think it should be used as an opportunity to just make those links that much better. But if this just becomes an excuse for insurance companies to charge ridiculous premiums, or for somebody to try and pass on their legal responsibility to the volunteer who was unlucky enough to be on the church door that day and let the terrorist in, I mean, that's not what this should be for.
How do you think this is going to work in practice? I agree that there are lots of duties already, but if you've got a health and safety duty on a group meeting in a village hall, say, and it's fairly common sense stuff in terms of there are no hazards there, there's hygiene issues if you're going to be serving food. But on a terrorism side, do you envisage that actually groups would have to make changes to the structure of a building, provide a safe room, for example, which is that really necessary for the horticultural show to be able to meet there, that there's a safe room in the event of a terrorist attack, whereas there have been, the Home Office were not able to give us any examples of terrorist attacks on village halls in the last 10 years. Do you envisage it would be that prescriptive?
It depends who's visiting the horticultural show. Mm-hmm. Are you visiting it? Do you have a high threat profile?
I exhibit, yes, but then anybody might be visiting a horticultural show who might have a higher risk profile.
Exactly.
In which case, every horticultural show meeting would have to provide a safe room, and every village hall that had any activities where there may be a chance of a local higher profile figure coming along would have to bring in those additional requirements, which could not be commercially viable, and therefore they close down. Isn't that the proportionality?
Well, I'm here to talk about places of worship, first of all. Secondly, I don't think that the bill does say any of that. I think what the bill does say is that for places of worship, unless you charge an entry fee and have a capacity of over 800, then basically you will be treated at the minimum level, as it were. You're a place that has a capacity for 100 people, therefore you need to have a plan and somebody designated as being responsible for that plan. And as I've already said, for me, that plan should be, this is how we evacuate, this is how we evacuate, this is how we contact the police, This is how we have some idea of who we do or don't want in the building. If we see somebody who looks suspicious, this is how we react. And there's a world of difference between that and building safe rooms in case an MP with a high threat profile should decide to visit a horticultural society fair.
So you would draw a distinction that it will be reasonable and proportionate that there is training about procedures, but if it started going into redesign of locations in order to make them more terrorist adverse, then that would be problematic, whether it's a village hall or whether it's some churches. And to come back to the example of places of worship, there are 40,000 places of worship in the UK, roughly. 16,000 of those are Anglican churches, of which I can't think of attacks that there have been, but of course synagogues and mosques have been,
right,
regretfully, the subject of attacks. You can't really have a policy that says that synagogues and mosques must, by law, have these, but the village church is exempt. So effectively, all 40,000 of those places of worship are going to be covered. But is it just about processes and procedures, or are you talking about redesigning church emergency exits and things like that as well, effectively, which then does become problematic?
I'm not talking about that being in law, but in the early 2000s, 2 synagogues in Istanbul were attacked by Al-Qaeda car bombs, and the vast majority of casualties were caused by flying glass. After that, for a number of years, my own charity was Britain's biggest single purchaser of protective film for glass windows. Why? Because we went to Istanbul, we saw what had happened, we learned the lessons, we decided that there was a big enough security risk to Jewish communities here in the UK that we would invest in putting film across every single outward-facing window. And then, when we were doing that process, we had it explained to us that if the window won't shatter, then actually the glass itself travels as a projectile. So we then had to reinforce the window frames at a number of external-facing windows. Now, we do that because we perceive a certain level of risk to synagogues and to other Jewish communal sites, and we believe that it's worth that investment. Similarly, when we build new schools, we do our utmost to build them as far away from the public highway as possible. We're involved, my own organisation is involved at the architectural stage of the planning of new Jewish schools, and that's because in 1994, Hezbollah drove a truck bomb up against the Jewish community centre in Buenos Aires, murdered 84 people. And we're all at equal risk of terrorist attack when we get on the tube or when we go to a concert. But when a religious minority is singled out for a terrorist attack, the impact that that can have on that minority's sense of not just safety and security, but future and belonging in a country can be very dramatic indeed. So that's why we feel the need to do it. It's proportionate, we feel, for us, but I'm not going to sit here and tell churches that they need to do it.
That's the really interesting point, and it's really helpful to have those examples of very real threats, present and historic. But you chose to do that without any legislation. Why does it now require legislation to make you and others carry on that good practice?
We don't need the legislation within the Jewish community. We do it because the Jewish community wants to protect itself. But the legislation as proposed, as I understand it anyway, is not that onerous. Literally, it is, here's a plan of our building, here is our awareness of the security threat to it, and we will work with, you should work with, local council and local police and the whole counter-terrorism apparatus to have something adequate in place that just enables the people who work at the building to know what they should do, to know who to shout if they see something suspicious, to know how to close the front door, to know where to evacuate to know how to evacuate. Every building, I presume, has a fire exit. To be honest, I think that you're making more out of the legislation than currently exists. And I'm not saying that anything about what should occur for commercial premises. I'm just talking about places of worship. And synagogues and mosques at the moment are I would say, at relatively high risk of terrorist attack.
I don't think anybody would.
Yeah, but
that.
what you said initially, you can't therefore just legislate out for those two premises.
No. The trouble is, as early witnesses said, the devil is in the detail, and because we don't know exactly the scope and the powers of the regulator.
Yeah.
So conceivably, if for good practice, entirely understandably, synagogues and maybe mosques following suit as well, or putting film over windows and things like that. There's a lot of stained glass windows in churches as well. Why shouldn't regulators say, well, everyone now has to put film over windows? That then becomes problematic. So I sort of understand in terms of good practice in procedures and processes, but then if it starts to tread into physical terrain, then it can become problematic. I've finished it with Mr. Kill. Welcome back, because I think you've given evidence in front of us before on numerous different subjects. Do you have a problem with non-commercial premises being treated with a much softer touch or giving far greater exemptions, notwithstanding some real risks?
As you can appreciate, that's not my expertise, but what I would say is it all draws back to proportionality principle. I think we've got to... however or whatever size the event is or the site, there will always be a fire risk assessment or a means of escape. So what we're talking about is something that, in terms of processes and procedures, as is highlighted by my colleague here, is already in situ. What we're talking about is just some initial thought process against the risks. And the risk could be geographical location, vicinity to important infrastructure, who's visiting, the type of clients that are coming, etc., that will present different levels in terms of those considerations. But any public accessible space could become a target, whether it's 50 or 2,000 people or 90,000 people at a festival. As you can appreciate, the risks are scalable and have to be considered. But it all draws down to the framework of proportionality consideration as we move forward. And as you quite rightly said, there were very much some at the low end, but what that framework looks like and the detail within that framework will give us a greater understanding of the approach and will give us a greater understanding of the impact assessment around it. But at present, that's where we're lacking. Thank you.
Paula Barker.
Yeah, thanks. Mr. Kill, I'd just like to ask, because Mr. Gordon has been very clear about the steps that his organisation take in terms of the threat that they face. Does the nighttime industry currently take any steps against terrorism? And if so, can you just talk us through what they are, please?
No problem. As I highlighted earlier, we already have a very stringent regulatory sort of position through the Licensing Act 2003, Health and Safety at Work, Private Security Act, and within that licensing framework there is a requirement of premises and events organisers to take account and include considerations around public safety and the prevention of crime and disorder. And it's probably important at this time to really highlight how important it is for those to interlock and integrate and align in terms of this duty and the potential duties that it will have to work alongside, including the regulators. So in terms of our sector as a whole, as you can appreciate, there are varying compliance levels dependent on the different categories of business. We see events and festivals organisers already have a due regard for counter-terrorism as part of their event management and security protocols, particularly with the scalability of some of these events, from Glastonbury to the likes of Reading Festival and Parklife. But they also have to go through a process of going through a safety advisory group. So there is an independent advisory group that will assess the event management plan and the security plan, which are made up of authority stakeholders, including police, planners, event organisers, and external stakeholders that will consider whether they have mitigated the risks that will be presented about putting on these events, from traffic to counter-terror to transport infrastructure, etc. Pubs, bars, venues, restaurants, etc. At that point, there is this disparity in compliance, being quite frank about it. There is a broad difference between independent businesses that have to fulfill this role and the risk assessments around counter-terrorism compared to the corporate side or the managed businesses that have a CSR position or a corporate responsibility position to safeguard what they're doing and a broader understanding. So we do see that there is a shortcoming so much in some of the smaller venues, particularly around independence. There is very much a wide use of third-party policy and procedure implementation. So what they will do is they will go out and use a third-party company who will help some of the independents, the lower end, what we will see in the lower tier or standard tier businesses to administer or get to a point where their risk assessments are in many respects generalised but are considered and then adapted on a local level through these sort of generalised sort of RAs. And within that you do see counter-terror strategy on a very basic level. Not so much the training, but there is definitely a process and an emergency protocol procedure which is considered. On a local level, dependent on the level of resource and expertise that you will see within policing, whether you're in a city or whether you're in a town or a village, will depend on what level of resource or expertise will be available within policing to then work within projects like Project Griffin, etc., which are counter-terror projects. And that also aligns itself to the level of intelligence that's being shared between the local authority or policing and the local businesses. And that's set up quite stringently, but is very, very different depending on the environments that people operate within, particularly the infrastructure that surrounds the spaces or environments that we're talking about. As you can appreciate, with the likes of Park Life, which is going on this weekend, you will see a full infrastructure and integration with the Safety Advisory Group, and this will have been planned since the end of the event last year, leading through to this event this year, whereas 100 capacity bar or pub which sits within a village will not have that resource requirement, will have a consideration for risk assessment and will have a consideration in terms of public safety, but not scalably at the level that we've seen with the likes of Park Life. So the other thing that I think is really, really important, and one thing that I brought up earlier, is we lack, in many respects, the proportionality principle within some of those sort of mid-range businesses, the 800 capacity to 2,000 capacity businesses, which don't have to go through the Safety Advisory Group process and may well need further support in terms of the considerations around this duty. But that's more with regard to the access to expertise and resource to support them within this period as we sort of move forward. But as of now, the disparity between the large-scale events who deliver quite readily and they have to go through a process, and the smaller businesses, many that sit within the standard environment, have a basic level of counter-terror process and emergency protocol, but as we move towards 800 capacity upwards, we do see a challenge there in terms of them being able to deliver to the level required within the duty.
Just on the issue of the third-party companies assisting with risk assessments, etc., we heard from Mrs Murray this morning about organisations which have been set up and they're going to businesses currently saying, we can assist you in terms of your compliance with Martyn's Law, which clearly is incorrect because Martyn's Law is not in legislation, yes, and there's lots of grey areas. Do all the third-party companies that obviously work with the nighttime industry have to be certified at a certain level?
In answer to the question, no. We do have some very clear challenges. It's something that I've highlighted to the Home Office and to regulatory bodies, that there is a concern that there are third-party companies going out and selling training at present for protect duty, counter-terrorism in terms of Martyn's Law. And what we've been very clear on, particularly with our members and the wider industry, is at present we don't know what the detail is. We cannot give a fulfilled training mechanism purely for the fact that it hasn't been brought to bear yet. We're not in that place. So for us, We feel that there is an issue at present with the market presenting training which potentially could cost businesses money, where they will have to reassess their training mechanism further down the line once the duty has got to a point of its, potentially to the point of its final stages.
Thank you. And Mr Gordon, can I just come back on a point that you raised about volunteers? It was something that I raised with Home Office colleagues this morning, because obviously we are aware that under this bill there would be a dedicated registered person. But I did talk about volunteers, and sometimes there's rogue employers, for example, or there's rogue organisations who would say, well, there's nothing to see here, it was all the fault of the volunteer. And you spoke in sort of very similar terms to that. Obviously, the CST is a very experienced organisation and works very effectively. Do you see any challenges in terms of volunteers to other faith organisations that they may not have thought of, where the CST could perhaps provide advice, guidance and support?
Absolutely. And it comes back to the previous questions about, okay, as a Jewish community, we perceive this level of threat, and for those reasons we do X, Y and Z. And you have to, as a church, as a Hindu temple, as a mosque, as a Sikh Gurdwara, you have to decide what you believe the level of threat is to you. We'd advise you to discuss it locally with police and local council, get a handle on that, understand a little bit as to when that risk may increase, depending upon circumstance or depending upon visitor to your premises. And we use a quote at the very beginning of these talks that we give, where people come from across all different faiths together while we give the Jewish experience. And in one of our first ever sessions, a vicar pointed out, well, hold on a minute, my church has an ethos and a religious instruction to welcome the stranger. And then he said, and this is literally what we quote, I get it. What we need to do is welcome the stranger, but make sure they're not there to harm us. And I would add, I think the bill provides another sentence to that. And if the stranger is there to harm us, then we need to know what to do. That's all this is. You know, just what are the basics of what we ought to do? So volunteers are absolutely critical to the running of places of worship. Doesn't matter what religion you are, it doesn't matter how big or small the premises are. They're absolutely central to it. And again, I've said it before, that comes back to, for me, it comes back to the spirit with which the law is applied. Is this supposed to be punitive, or is this supposed to be supportive? And I think it has to be supportive in its spirit and in its application. And if it can be somehow made supportive in its wording, then that should occur also.
Thank you. Thanks, Ms.
Thank you. Alison to you, Liz.
Yeah, I just want to come in briefly. My apologies for coming in late. I had to go and cover a Westminster Hall debate as well as coming here today. I just wanted to ask Mike, please, is there any kind of difference you perceive from some of your colleagues in Scotland? Because obviously legislation around licensing is slightly different there. There are slightly different responsibilities for licence holders and things. Is there anything particular there that we should be aware of, or anything particular there that would be useful to bring into the debate?
In terms of Scotland and the work that we do with the Commission and the body of, there isn't. I mean, the challenge really sort of represents it, as you quite rightly said, licensing legislation is different, but this is where that integration between current duties and provisions and this duty need to work together. When we talk about primacy, we also, and we talk about low-level primacy in terms of who's in control in complex situations, we will face a similar environment with regulatory bodies who will have to really understand who has primary positioning, whether it be licensing, protection of public spaces, etc. So there needs to be absolute clarity on how this works. So I think there are consistent challenges with regard to what I highlighted earlier in terms of language, consistency, etc., that will probably be very, very apparent across all devolved nations moving forward. So in simple terms, nothing separate apart from the legislative differences and where those devolved powers would sit in terms of influencing the implementation within Scotland, because we still have questions over the 800 capacity threshold. Is that with reference to the proportion of businesses across the country and the relevance or access to resource, CTSAs within policing, etc., and how will that be different in Scotland, given the fact that we're talking about a smaller police force, one police force amongst all, and the fact that there is a broader amount of coverage in terms of policing from the Highlands, the Central Belt, etc. So there are lots of considerations there that have to be around Scotland as a devolved government and the way that it's approached. But threshold-wise, it's an understanding of where that sort of sits and the influence that Scotland will have on that. Because as you can appreciate, I think the impact assessment suggests that the Secretary of State has the ability to drop down from 800 capacity to 500 capacity, where we are quite aware that our temporary event notice capacity is to 499, so we're not sure why 800 came in, although dropping to 500 would obviously present a more challenging consideration in terms of accessing expertise, policing pressures, etc. So I think there are lots of checks and balances here that need to be considered when we're actually looking at implementing this, because it is going to place pressure on training companies. Even if we look at hospitality as a whole, as 3.2 million people employed, to actually implement training even on a digital base and get people, particularly with the higher turnover of staff that we represent, not only in Scotland, Wales and England and Northern Ireland, but how are we going to effectively manage that is a huge concern. And the expertise in counter-terror at the enhanced level is going to be stretched without a doubt. And I'm not sure the impact assessment on the resource to access that expertise and the training mechanisms to deliver to such a huge audience effectively over a very short period of time potentially is being considered in all of this.
Would you say there needs to be a lot more resourcing put into that? Because clearly if more information is being gathered and put into a system, there needs to be some kind of analytics at the other side of that.
Well, you would hope. I mean, between the impact assessment on the current regulatory duties, you would have to understand the impact assessment on cost, which we still feel that £2,000 for a lower stated standard protect duty sort of venue against an 800 cap enhanced is hugely understated. I mean, when you talk about venues or spaces with such a high turnover, everything's going to be budgetary-wise front-loaded. You're going to see 40-50% of your cost at the outset, and then the maintenance is going to be quite high because of the training mechanisms of turning over. If you talk about festivals, I mean, Parklife as a festival has a nominal amount of staff which are permanent. The rest are all transient. So what you're talking about is replenishing this training on a continual basis. So we're talking about a huge consideration in terms of the infrastructure and development of a training course which is accessible and easy to pick up. But we're also not considering the bespoke site-specific training that's got to be undertaken and the timeline for that also.
Yeah, that's really interesting. So I represent Glasgow Central, so I've got the SEC and the Hydro, smaller venues, venues of all shapes and sizes, from King Tut's to the Barrowlands and everything else, but also Glasgow Green, where we've got Transmit happening as well. I'm just really conscious of what you said about training of security personnel. Is there more that the SIA need to be doing here to making sure that their operatives are up to scratch and ready for this?
I think yes. I mean, I also chair the UK Door Security Association. The concern that we have is we've recently gone through the Home Office a changing training mechanism over 2 years ago. There wasn't a great consideration in terms of counter-terrorism as far as we're concerned, not to the point that we consider this duty. And I think the other thing that I think is really, really important to understand is the transient nature of door security at the moment. I mean, during the pandemic, we saw probably an 80% pre-COVID resource level. What we're concerned about now, which has been highlighted to the Home Office, is while we talk about the approved contractor scheme having some 800-900 contractors within it, there are some 4,000 that are untraceable, untrackable in terms of delivering security resource. Surely at some point, through registration or business licensing, that has to be a consideration to fill that void and allow us to make sure that we've got a managed and understood group of companies that deliver security resource, because at the moment it potentially could compromise the whole duty.
Okay, can I thank you very much indeed. That concludes our session today. If there's anything you would like that you haven't been able to say, please do send in writing any points that you feel that we haven't addressed. So thank you very much. Could I just get the committee to agree that we publish the written evidence? Is everyone agreed on that? Yeah, thank you very much. And thank you again for your time. Thank you.